Okay, everybody. In this lecture, we're going to talk a little bit about Nixon and his views on civil liberties and some of his violations of civil rights. This comes out of the chapter 11 in the Rees book. And also, we're going to be looking at chapter 13 in the Irony book. All right, so we're going to be talking about civil rights. We're going to be talking a little bit about the PATRIOT Act, which, as you all know, we have our May 1st paper due, and it's a question regarding the PATRIOT Act, okay? So, a couple of things. When we talk about Nixon, Nixon was kind of a gruff individual. Coming out of, um, the passage of the civil rights movement and out of LBJ's fight to kind of continue Kennedy's legacy with the Civil Rights Act, Nixon kind of seemed both for and against the civil rights movement. One of the first goals that he had was to impose racial equality within his administration. He approved what was called the Philadelphia Plan that required contractors to bid on federal projects and make a good faith effort to try and hire minorities as part of that workforce. However, Nixon also kind of followed the Southern strategy where he was catering to white voters in the South by attempting to slow down desegregation in the schools. But on the other hand, he also encouraged the EEOC, or the Equal Employment Opportunity Commission, to force private employers to accept hiring of minorities and women. So, you could see Nixon was a little bit for and against civil rights. Nixon also chose to adopt a policy based on a unitary school system. However, in order to avoid that controversial issue of busing, he favored on the basis where children, without taking account in race, would attend school to the closest to their residence, which really happens right now. Nixon also pursued the strategy of black capitalism, which increased employment opportunities for blacks. He also implemented Executive Order 11458. And as we know, executive orders have the weight as laws, much like a law that Congress passed. But this is more a directive from the president to the bureaucracy to carry out a goal or a law. He established out of this executive order the Office of Minority Business Enterprise, which expanded the federal look for firms owned by African Americans and gave them, contracts that dealt with the government. Some of the other actions that were relevant today are the Controlled Substance Act that Nixon signed into law in 1970. The CSA, along with, the Food and Drug Administration and the DEA, scheduled drugs according to 5 different schedules based on their medical application and potential for abuse. Scheduled 1 drugs, which are controlled substances, and if you don't have a prescription for them, or if it's an illicit drug, you could pretty much be facing some jail time. So we look at here, Scheduled 1 drugs involve heroin, LSD, cannabis, and ecstasy, right? So it's kind of obvious, too, when you see that, some of the screwiness out of this Controlled Substance Act, that cannabis and heroin are on the same schedule, right? Now, if you look at Schedule 2, you have your opiates and your cocaine. Cocaine is considered a Schedule 2 drug because it does have some medicinal purposes for it. Opiates, as we all know, the opiate problem that exists here in the United States with pain medication and things like OxyContin and Vicodin are Schedule 2 drugs, meaning you need a prescription to be able to take that drug, and the doctor has to limit it. And there's a bunch of different things that come into that we're really not going to get into. But when you hear the schedules, this is what they're talking about. Schedule 3 are your steroids or your Tylenol with codeine. Now, when we're talking about steroids, we're not necessarily talking about performance-enhancing drugs. You can take a steroid if you have asthma for as an inhaler. You can use steroid cream for any type of maybe psoriasis or skin affliction that you have. So it's not necessarily performance-enhancing drugs. And then our Schedule 4, which are your Xanax, which is an anti-anxiety medication. Valium, same thing. Ambien, which is a insomnia medication. Tramadol. Those are Schedule 4 drugs. And then we have Schedule 5 drugs that are antidiarrheal, antitussive, which means anti-cough, and angiocytic purposes, meaning pain relief. Nixon, along with the DEA and the FDA, instituted these schedules, and as we know, as part of Nixon's War on Drugs initiative, we started to see mandatory prison sentencing for drug crimes that kind of affects us still today. Nixon also kind of violated civil liberties by running a program called COINTELPRO, or the Counterintelligence Program. It was kind of a series of events that were covert and at times illegal, where the FBI was surveilling, infiltrating, discrediting, and trying to dig up dirt on domestic political organizations. In March 8th of 1971, an anti-war group called the Citizens Commission to investigate the FBI broke into an FBI office in Pennsylvania and discovered a cache of classified documents titled COINTELPRO. Beginning in 1969, leaders of the Black Panthers were targeted under COINTELPRO. Some of them were murdered, assassinated, imprisoned. They were also kind of caused to fight with each other, right? So some of the Black Panthers affected were Fred Hampton, Mark Clark, Zayad Shakur, who is no relation to Tupac, Geronimo Pratt, and Wamuya Abdul-Jamal, two individuals that are still in prison today. If you want to learn about some interesting kind of stories, those two have some compelling stories, and you know, there's been some arguments, especially with Wamuya Abdul-Jamal, who was, you know, kind of accused and convicted of killing a police officer in Philadelphia. Some people are questioning the validity of his conviction. Among them are the group Rage Against the Machine, who are a really outspoken advocate for his release. So if you are interested in reading about some of that stuff, he's a compelling figure to look at. COINTELPRO also encompassed the Socialist Workers' Party, which is a funny name when you think about it, because what was the original Socialist Workers' Party? Isn't it the Nazis? The Klan, the Nation of Islam, the Black Panther Party, leftist groups, anti-war groups were all being investigated by the government. What they would do is they would create a negative image for these groups and have the public turn against them. Then they would also kind of infiltrate the internal organizations by creating conflicts between leaders, which would exacerbate tensions and try to create conflict. They would create dissension between groups by spreading rumors, restrict access to public resources by pressuring nonprofit organizations to cut off funding, and to restrict the ability to organize protests through agents, promoting violence against police during planning and of protests. And they also restricted the ability of individuals to participate in group activities by, making assassinations of their character or arresting them or surveilling on them illegally. Nixon also authorized wiretaps, which produced for the White House purely political purposes. Information unrelated to national security, including information about a Supreme Court judge. One thing that we're going to notice throughout history is that anytime there's some type of conflict or there's some type of interesting event, and we could even tie it into the COVID-19 virus, that at times the government's going to try to minimize or try to in a sense roll back some of our civil liberties, whether it's a catastrophic event, a natural disaster, or a terrorist attack. If we look at this, one of the first things that happened was in response to the threat of the French in 1789, President John Adams instituted the Alien and Sedition Act, which made it easier to deport immigrants and restrict the right to vote. You could be fined or imprisoned for publishing anything that was written, printed, uttered, or published any false, scandalous, malicious writing against the government. Now, we're not to 1791 yet, so we don't have the First Amendment, but you can definitely see when we have the First Amendment, this is kind of conflicting with it, right? During the Civil War, Lincoln, who's been one of the more beloved presidents here, suspended the habeas corpus, which is, habeas corpus is Latin for release the body, meaning that if you're detained by the government and you're not charged and ran through that due process system, a lawyer can institute what's called a writ of habeas corpus and get you out of detainment. Nixon suspended this at that time. And he was federally able to do that through the suspension clause, Article 1, Section 9, Clause 2 of the Constitution. World War I, we had the Espionage Act, which made it a crime for any person to convey information intended to interfere with the U.S. Armed Forces prosecution of the war. And it was intended to prohibit with military option or recruitment to prevent kind of insubordination in the military and to prevent the support of U.S. enemies during wartime. So it'd kind of be like illegal, much like now if we would harbor an enemy. It's like the Palmer raids. The Palmer raids were a series of raids that were conducted by the U.S. DOJ, the U.S. Department of Justice, during the presidency of Woodrow Wilson. The goal was to capture suspected leftists, anarchists, and deport them from the U.S. It kind of evolved out of a speech made by Wilson in 1915, when Wilson warned against hyphenated Americans who had poured the poison of disloyalty into the very arteries of our national life. Such creatures of passion, disloyal, and anarchy must be crushed out. We also had the Sedition Act of 1918, which made it an offense to, notably among speech and expression of opinion that casts the government or the war effort in a negative light or interfere with the sale of government bonds. Now, criticizing the government here, First Amendment violation seems to be so, right? Then we have World War II, right? Executive Order 9066. 110 to 120,000 people of Japanese ancestry were put into internment camps. Was this a violation of the Fifth Amendment and the 14th Amendment? I believe so. Out of this came a court case called Korematsu versus the United States. Freddie Korematsu asked the Supreme Court of the U.S. to hear his case. Mr. Korematsu was detained as in an internment camp. When his case was heard, the Supreme Court in a 6-3 decision felt that detainment of Japanese Americans was based off of a military necessity, not so much based off of race, which was kind of ironic because you had more Nazi and Italian sympathizers in New York City than you had Japanese Americans on the West Coast. So, I do not believe or buy that it was not based on race. Then we have something called the Patriot Act, right? And the Patriot Act is a controversial act, and we're going to discuss a little bit of it. Okay, so let's start up, talk about the Patriot Act. So the Patriot Act was passed in response to 9/11. Stands for the unity and strengthening of America, providing appropriate tools required to intercept and obstruct terrorism. So the USA Patriot Act was passed on October 26, 2001. This is a copy of the act. And one thing that we need to know about the act is that the act is, around 300 to 400 pages. On October 23rd, Representative Jim Sensenbrenner introduced the bill. On October 24th, that bill was passed in the House 357 to 66, with Democrats comprising the overwhelming portion of the Senate. On October 25th, the act was passed by the Senate 98 to 1, and then it was subsequently signed by the President on October 26th. My main concern about this act is it gives away a lot of our civil liberties, and also look at the quickness that it was passed in. It was originally, passed in response to 9/11, a very large act that was introduced on October 23rd and then eventually signed on October 26th. I mean, look how quickly this piece of legislation went through. Some of the things that are important about the Patriot Act are Section 215, which sanctions the seizure of anything tangible without warrant that the government has reason to believe is affiliated with an act of terrorism. So these tangible things can be books, records, papers, documents, your orders on Amazon, right? So the government can look in these without, if they believe anything is a tangible item that might aid in terrorism, they can look at it. That includes, like I said, books, reading revolutionary books. That's another thing. So if you read Common Sense, you might be flagged. Just, kind of a thought about that. Okay, Section 206 permits roving John Doe wiretaps, meaning the governments can surveil and wiretap of a specific person without a warrant. So, putting bugs on your phones or putting microphones in your office. If you're considered to be engaging in a potential act of terror, which is already kind of a broad scope definition anyways, the government can surveil against you. Section 6001, or the lone wolf provision, authorize secret surveillance of non-U.S. citizens who give the government reason to believe he or she will participate in an act in international terrorism. Now, some of the questions of this is some of the broadness in the definitions that, what do we consider to be a terrorist? What do we consider to be a terrorist act, right? One of the things that is kind of interesting about this is the government has the power to go through your financial records, your medical history, your internet usage, your bookstore purchases, library travel, or anything that leaves a record if they consider you to potentially be a terror suspect. I think that's one of the key things, one of the interesting things when you say, what's the problem with the Patriot Act? It seems like it's used to try to fight terror, but then the government can maybe frame it in a way that, they can use it as an excuse to maybe surveil anybody. Now, we're going to look at some important Supreme Court cases, right? And these are good cases that if you want to look at and use for your Supreme Court paper, by all means. Hamdi versus Rumsfeld. This is a Fifth Amendment case. Hamdi was an American citizen. He was detained by the U.S. military in Afghanistan. He was born in New Orleans, and then he moved to Afghanistan at the age of 1 and joined the Taliban. Right? He was accused of fighting the Taliban and declared an enemy combatant and was held in Guantanamo Bay. It was argued that the government had violated Hamdi's Fifth Amendment rights to due process by holding him indefinitely and not giving him access to a trial or an attorney. The government basically said that the executive branch had a right during wartime to declare people who fight against the United States as enemy combatants, and thus they can restrict their court access or the court system or their right to due process. Basically what the court found was that they agreed that the executive branch doesn't have the power to hold a U.S. citizen indefinitely without due process, but they can extend that to people that are non-U.S. citizens. So basically, if you're a U.S. citizen, you're always going to be entitled to due process, even if you're considered to be an enemy combatant. But if you're a non-U.S. citizen or an illegal or a permanent resident or whatever, they can detain you without due process of law. Now, when we talk about freedom of expression, Gitlow versus New York is an interesting one. Gitlow was a socialist who was arrested for distributing copies of a left-wing manifesto. He advocated the establishment of socialism through strikes and class action, or collective action. He was convicted under a state criminal anarchy law and was punished advocating overthrow of the government by force. This is kind of comes to the point where when do we have free speech and when we don't? Obviously, we can't be arrested for anything that we say, but there are standards that if our statements create what's called a clear and present danger, then we can be arrested for it, right? So if we say something that might create a social disturbance, like right now is not a good example, but if I go into a crowded movie theater and yell fire, right? I can do that, that's fine, but I might face a consequence because that creates a clear and present danger. Or if I go to the airport and yell bomb, right, I'm able to do that, but, there's consequences if you do that. Miller versus California is another interesting case. Miller was sending pornographic material through the mail, and he was arrested for it. Some unwilling recipients of Miller's brochures complained to the police. So there is some concerning things about, art and pornography and kind of the fine line through it. If something is to be considered obscene, it has to pass kind of these three-tiered tests that we have. would it offend the average person using community standards? Right? If it does offend the average person using basic community standards, then it could possibly be obscene. Is the work in question illegal? So, pornography involving adults is legal to a certain extent, but if there's something that's illegal, like the use of children or something like that, and it's against the law, then it's considered to be obscene. So child porn would not be protected by the Constitution. And lastly, is the work taken as a whole, does it lack serious literary, artistic, political, or scientific value? So if that happens, and if you meet all these standards, then something can be considered to be obscene. Lemon versus Kurtzman basically says that, is it illegal for states to provide funding for non-public, non-secular schools? Does that violate the First Amendment? Yes. The statute must have a secular legislative purpose, so the government can't give religious-based private schools public monies, because it's a violation of the Establishment Clause of the First Amendment. Now we have a Fourth Amendment question. Mapp versus Ohio. Dollery Mapp was suspected of hiding a person who was accused of a bombing in Cleveland, Ohio. They knocked on her door and demanded entrance, but Mapp refused because they did not have a warrant. When they searched Mapp's house without a warrant, they found pornographic material. They arrested Mapp based off of an Ohio law against the possession of obscene material. The court determined that the evidence obtained through a search violated the Fourth Amendment and is inadmissible in state court. So what this establishes what's called the exclusionary rule. Right? The exclusionary rule basically says that if the police do not have a proper warrant in the search of a home or the search of a person or the search of property, then that evidence can be excluded from trial. Now, are there certain provisions to that? If you are driving a car and speeding and the car smells like marijuana smoke or alcohol or whatever, that gives the police officer the reason to believe that another crime is being committed, so they have the right to search. If they see something that's in plain view, they have the right to search. Right? So if you're driving and you're speeding and they see a gun on your passenger seat, it's illegal, so they have a right to search. If you're running, if the police tell you to stop and you run, or you run in a car, or you drive off, they have a right to search you then because you're in flight. Gideon versus Wainright is one of the more interesting cases. What Gideon versus Wainright basically says that anytime we're charged with a crime, no matter what the crime is, we're entitled to an attorney, right? And remember, and I really want to stress this only has to do with criminal cases. So Gideon was a felon who had broke into a pool room with the intent to commit a misdemeanor offense. He requested a lawyer. However, at that time, Florida law only said you could have a lawyer if you're facing a capital case, or capital case is a death penalty case or a life in prison case. So he didn't get one. And what we found out of this is the Sixth Amendment extends counsel to criminal cases. Now, one thing that I also want you guys to understand, this is in criminal cases only. So if we're charged with a crime, yes, we're entitled to an attorney, but what happens if we're sued by somebody civilly? We're not necessarily entitled to an attorney, okay? So that's the important thing to understand, is that with Gideon versus Wainright, in criminal cases, we're entitled to an attorney. But if it's a civil case, we're really not. Now, Miranda versus Arizona, Fifth Amendment, against self-incrimination. We all know the Miranda rights. We learned it from TV, movies, and we definitely know these are things we do not want to hear. Because if we're hearing the Miranda rights, what is happening? We're being arrested, right? So what the Miranda case was, Ernesto Miranda was a felon who was trying to commit a forcible rape. And when he was taken to the police station, he wasn't informed of his right to remain silent, and he confessed. Now, what this does now is it gives the government the responsibility to let us know about our Fifth Amendment rights. Griswold versus Connecticut is another interesting case. Griswold was the executive director of Planned Parenthood. This happened in 1963-ish, 1964. And what Griswold did at the time was give family planning advice to a married couple. In Connecticut at that time, that was illegal, even though the couple was married, right? So what happened with this was, the question is, does the Constitution protect the rights of marital privacy against state restrictions on a couple's ability to be counseled in the use of contraceptives? What comes out of this is if we lump in the First, Third, Fourth, and Ninth Amendment, it creates what is called as a right to privacy within the Constitution. So we have a right to privacy in marital relations. Therefore, the Connecticut statute that was argued in Griswold versus Connecticut was null. This extends to Roe versus Wade, and a lot of people are more familiar with Roe versus Wade than they are with Griswold versus Connecticut, but we need to understand Griswold versus Connecticut is a landmark case that had a profound influence on Roe. Does the Constitution embrace a woman's right to terminate her pregnancy by abortion? What the court found is the court held that a woman's right to an abortion fell within the right to privacy that was established by Griswold, and therefore protected by the 14th Amendment. Now, it also gave women autonomy over the pregnancy during their first trimester, but we can have state and federal restrictions within the second and third trimester. Okay, so those are some important Supreme Court cases that I thought were interesting. When we come back, we'll talk about civil rights and we'll talk about different civil rights movements.